We have massive news right now. The Trump Justice Department made a huge mistake that could cost Lindsay Halligan, Donald Trump's personal attorney, current U.S. attorney for the Eastern District of Virginia, her law license, could completely dismiss James Comey's indictment in a complete egg in the face moment for the Trump administration. This was Donald Trump's quintessential prosecution, and it's about to go down in flames because just minutes ago, a federal judge ruled that James Comey's team can have access to secret grand jury materials that, folks, criminal defendants never get access to. I have practiced law for several years. As part of my practice, I did a lot of grand jury work. To get grand jury materials, there has to be such an abuse of power from the government, and here there is one. So make sure everyone knows. So like, comment, share, and subscribe, because this could set the stage for Lindsay Halligan to be removed from her post, potentially lose her law license over how egregious the mistake that she made was. So I want to jump through this stunning opinion. It's in the United States of America versus James Comey. The judge rules, this matter is before the court to address the narrow issue of whether there are particularized and factually based grounds to justify the disclosure of grand jury materials to the defense pursuant to Federal Rule of Criminal Procedure 6E3E2. For the reasons set forth below, the court finds the record in this case requires the full disclosure of grand jury materials. In so finding, the court recognizes this is an extraordinary remedy. But given the factually based challenges the defense has raised to the government's conduct and the prospect the government misconduct may have tainted the grand jury proceedings, disclosure of grand jury materials under these unique circumstances is necessary to fully protect the rights of the accused. This never happens. So they gave Comey all of the grand jury materials. And while I'm going to skip to the end and then we're going to go through the ruling together, because when I say it's stunning, me as a former white-collar defense attorney, I'm stunned because I never thought I would see the day where this remedy is granted. So this is the conclusion from Judge Fitzpatrick. The court recognizes that the relief sought by the defense is rarely granted. However, the record points to a disturbing pattern of profound investigative missteps that led an FBI agent and a prosecutor to potentially undermine the integrity of the grand jury proceeding. Therefore, in this case, the court has before it a rare example of a criminal defendant who can actually make a particularized and factually based showing that grounds exist to support the proposition that irregularities may have occurred in the grand jury proceedings and may justify the dismissal of one or more counts of the indictment. Accordingly, the defense request for all grand jury materials is granted. That last line of the quote, that this tainted grand jury proceeding could lead to one or more counts in the indictment being dismissed, is significant. Now let's go through why this happened, because I think people need to know. So first, there are about 11 reasons. This is reason number 2. The prosecutor told the grand jury that there was blank, and then it's redacted. But read this next statement. That statement clearly suggested to the grand jury that they did not have to rely on only the record before them to determine probable cause, but could be assured the government had more evidence, perhaps better evidence, that would be presented at trial. Folks, a key tenet in a criminal prosecution, a federal criminal prosecution, the evidence you put forth in front of a grand jury is the evidence you have. Once you indict an individual, you cannot continue an investigation, right? So they can't go and pursue this indictment against James Comey and then the next day go and interview more witnesses. No. Once you indict, you're done. You have the evidence, you presented it to the grand jury. That's what the probable cause is based on. Probable cause, the likelihood of a crime being committed. And that's the evidence you use when taking the case through the pretrial and eventually through trial. Here, they're suggesting, Lindsay Halligan suggested that, maybe, just maybe, there's some more evidence, some better evidence that would be later presented at trial that they're not presenting to the grand jury. What that signals to me is that they didn't have the evidence in the grand jury. They rushed it, and they were going to continue to investigate Comey, which is not allowed. That's a violation of every ethical conduct in the book. Let's move on. Next, this one was stunning to me. The prosecutor's statement that blank is a fundamental and highly prejudicial misstatement of the law that suggests to the grand jury that Mr. Comey does not have a Fifth Amendment right not to testify at trial. The prosecutor's statement ignores the foundational rule of law that if Mr. Comey exercised his right not to testify, the jury could draw no negative inference from that decision. The prosecutor's statement that blank may have reasonably set an expectation in the minds of the grand jurors that rather than the government bear the burden to prove Mr. Comey's guilt beyond a reasonable doubt at trial, the burden shifts to Mr. Comey to explain away the government's evidence. In criminal law, every criminal defendant has a Fifth Amendment right not to testify at trial. That is a key protection. And almost always, the easiest way for a prosecutor to get their indictment kicked out, well, they go in front of a jury and they say, you know what? So-and-so did not testify at trial today. You can't do that. You can't essentially impute guilt on someone because they didn't testify in their own criminal proceedings. That is, when I tell you that's the biggest thing, huge. And the fact that she did this behind the scenes in a grand jury, remember, in a grand jury proceedings, there's no judge. It's just the prosecutor and anywhere from 10 to 23 or so grand jurors. That's it, 12 to 23. There are no judges. And so there was no judge to decide. If she was in a courtroom and did this, judge would have thrown the case out immediately. Let's move on. If this procedure did not take place, then the court is in uncharted legal territory, and that the indictment returned in open court was not the same charging document presented and deliberated upon the grand jury. Either way, this unusual series of events, still not fully explained by the prosecutor's declaration, calls into question the presumption of regularity generally associated with grand jury proceedings and provides another genuine issue the defense may raise to challenge the manner in which the government obtained the indictment. What does this mean? This means that essentially what the court got, because here's how a grand jury works. Prosecutor gets up there, witnesses testify, prosecutor asks the grand jury to issue an indictment. They issue an indictment by a vote. Then the prosecutor takes that indictment, which is secret, goes in front of a magistrate judge and says, Your Honor, here's our indictment. Please sign the indictment, issue an arrest warrant. Let's go get our guy. Now, something happened here. The judge is saying that between what happened behind the scenes in the grand jury to the indictment being brought up to the magistrate, something changed. You can't do that. That's an irregular issue. And so that's another issue brought before the grand jury, brought before this court. Next up. Ninth, the nature and circumstances surrounding the disclosure of potentially privileged information establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard of the law. You cannot disclose privileged material in front of a grand jury. Privileged material is like, for example, if James Comey spoke to his attorney, that's attorney-client privilege. That privilege cannot be pierced absent extraordinary circumstances, and there were none here. If Lindsay Halligan pierced it, she could have her law license revoked. In addition, 10th, as discussed in Section 4 above, the prosecutor made statements to the grand jury that could reasonably form the basis for the defense to challenge whether the grand jury proceedings were infected with constitutional error. Folks, judges never make statements like this. It is a stunning, stunning fall from grace for this Trump prosecution. If I predict they're going to get these grand jury materials, they're going to find misconduct in the grand jury proceedings. And you know what's going to end up happening? Comey's going to walk. Lindsay Halligan's next up for a bar complaint. Like, comment, share, and subscribe. I'll see you soon for more.